Hi, welcome back to Legal Time. My name is Anna Rana. I'm a solicitor advocate with Connaughts, and to my left is Mr. Wais David, a partner and solicitor who deals with immigration. Now, as you're aware, Legal Time is a platform where we deal with live questions which you send over to us, as we are dealing with this program right now, and we give updates on the law and just share our knowledge with the general public. Now, before we go on with the live questions that we're receiving or that we would receive at the moment, we would go through questions that we've received in the past week, common questions that we received from different clients, and we've thought that it's better that we just address this in our live show and just go over it. So I'll go with the questions one by one. Okay, starting with the first question. One of the clients has come up to us and he said that he wanted to apply for a permanent residency application. Now, he's been with the partner for, say, 4.5 years, so not even 5 years yet. And he's now separating with the partner and he's saying, because I've not completed my 5 years, can I still apply for a PR application?
Well, in this case, obviously, once they have separated, the route he can take, he can apply for PR. Problem he might face is that he needs to provide evidence that relationship was genuine to begin with. In this case scenario, another step they can take if they are separated and marriage is irretrievably broken down, they can apply for divorce. Mm-hmm. Divorce generally takes 4 months, 3 to 4 months, could take up to 5 to 6 months. And by the time divorce is finalized, this gentleman has finished his 5 years from the date of marriage as a family member of an EEA national. At this stage, if he has evidence to show that his ex-spouse was exercising treaty rights before the divorce, from the date of marriage up to the point of divorce, and after the point of divorce that he is working in the UK or exercising treaty rights in other ways, he can apply for indefinite leave to remain, permanent residency as they call it. So this is one of the ways he can secure his position.
Just to stop you there, that 5 years, is it up to the time when divorce is initiated or when it's finalised, just to clarify?
Well, 5 years are from the date of marriage, regardless of whether divorce is initiated or finalised. From the date of marriage, as soon as 5 years are finished, if divorce is still pending, you will have to wait until divorce finishes, finalizes. If not, if they are applying on the basis that divorce proceedings are going on, they will have to wait for the divorce to be finished, to be finalized. Once divorce is finalized, evidence needs to be provided from the date of marriage up to the point of divorce from the ex-spouse, that ex-spouse was exercising treaty rights. They also need to still provide evidence that they were living together in the UK for 12 months, because it's essentially retained right of residence application. But because altogether from the date of marriage 5 years have been achieved, and this person can make an application for permanent residency rather than applying for another 5 years continuous stay in the UK. So it doesn't have to be 5 years continuous stay on the basis of retained right. Can obtain permanent residency straight away.
Okay. And another question in relation to PR application that we received, does the EEA national need to be earning like a set amount? Is there a minimum threshold?
Generally, there is no specific minimum threshold, but generally it's advisable that that they at least earn an amount where they start paying national insurance, which is, I think, is approximately 157 or 58 pounds, 160 pounds. Obviously, it needs to be double checked, which per week. So it's about approximately 670 or 80 pounds a month. Approximately, yes. So whatever the calculations are, this is the amount when you start paying national insurance. So HMRC will have a record of your employment and national insurance. So that is something that will be very useful. If the EEA nationals are not earning up to that point, then Home Office has to do some extra checks, and it may result in a refusal as well if they can't find enough evidence to show to obviously come to a conclusion that EEA family members are exercising EEA nationals are exercising their treaty rights. So that is something I think everyone should try and meet this threshold.
Okay, thank you for that. Moving on to our next question. We also received an inquiry saying I got my visa on the basis of my British child and partner, which was on the 10-year route, but my relationship has now irretrievably broken down. My visa is expiring soon. What should I do?
So you understood is someone's married to
A British
citizen.
partner.
Yeah.
Okay, she's got a British child from that person, and they're on the 10-year route, but now marriage has broken down. What can she do? Her visa is expiring soon.
Okay, well, it really depends if this lady still has custody of the child or not.
Okay.
We'll discuss both the scenarios. If this lady still has custody of the child, then she can make an application as a primary care of a citizen. So I don't think there will be any problems if she already had a visa as a family unit where her husband was a British citizen, or if or a child was a British citizen. Now she can simply apply for an extension on the basis that she has a child with a British citizen. Shouldn't be a problem. If she does not have a custody of the child, or let's say if it's a father of the child is separated from the mother and mother is the British citizen spouse, as soon as visa runs out, need to make an application on the basis of access to British child. So if father has contact order in place, we discussed this in our previous program as well. If father has contact order in place or some sort of agreement in place with the mother, or vice versa, that they can see the child regularly, then they can make an application on the basis that they have access to a child with a British citizen, and they should get a visa on those basis 2.5 years at a time. If they can show that they're able to maintain themselves and they meet the certain English language requirement, which is I think A1 equivalent, then they can actually get on to a 5 years route as well on the basis of the child. So this is the option they have. If there is no contact order in place and parties cannot, ex-fathers cannot agree on the contact order, then obviously this needs to be done by family courts. As long as proceedings are initiated in family court, proceedings are going on, applications still can be made. Generally speaking, Secretary of State will put this application on hold until the decision from the family proceedings comes out and it's finalized whether the particular applicant has contact rights or not to see that child.
Okay, thank you for that. Just another question arising from what you were saying. For the 5-year route, you mentioned that they need an English language. Is that just limited to that? Is there a financial requirement as well?
Yes, as I said, they need to show that they are able to maintain and accommodate themselves. Okay. So there is no specific threshold they need to meet, but need to show that they are earning enough. Obviously, they'll have to have right to work in the first place, or they need to show that they're able to maintain and accommodate themselves.
Okay, moving on to another inquiry. Okay, I'm just going to distill this question down and ask you a summarised version. Question is, can she apply for interference on the basis of her children who are British, okay, and she is now no longer with the husband, or she's planning on divorcing the husband?
Okay, why I understood from this question was, I've read this question before, where husband has custody of the children in the UK, non-British spouse has left the UK but now wants to come back. Again, same principle, spouse, non-British spouse, if a couple are not separate, are not together, they're separated, and she can make an application on the basis that she has a right to see her children, and she should be able to get a visa on those bases. We have done this type of applications previously. If they are together, then obviously husband needs to meet income threshold. If he meets income threshold for 18,600, she can make an application and come in. If not, then application can be made on a discretionary basis and acceptance circumstances, because it's an entry clearance application. Obviously, the chances are a bit reduced as compared to in-country application. If it was a scenario where there's an in-country application, she probably would have got this visa easily on the basis that she has either access to children of British citizens, or she's a part of this family unit where she's a primary care of these British children if they're living as a family unit together.
Thank you. Moving on to the question. We received an inquiry saying, I got citizenship through naturalisation in the UK, married in the UK, I have a child born in Gambia, but I'm not married with the lady to whom I've had the child with. Can I apply for British passport
for that child.
for the child in Gambia?
It really depends. If this gentleman has obtained citizenship other than by descent, which he's saying he has, then if child is born after the citizenship, if child is born before the citizenship is obtained, child obviously cannot apply to be citizen. If child is born after this gentleman has obtained his citizenship, then because he's a biological father, in theory, child is a born citizen, so child should be able to apply for a passport and travel passport as a citizen. Having said that, there is a provision in nationality law where at the time of birth of the child, whoever is married to the mother of the child will be considered the father. This situation was challenged in the court, and there was a decision from the court which we have discussed in our previous programs as well. I think it's section 50, subsection 52, subsection 9. Don't quote me on that, can't remember from the top of my head right now. Where it was considered by the court that this section of the Nationality Act is not in accordance with the Human Rights Act. So I think particularly section 27 mentioned. We also have cases pending on these bases. We are dealing with a couple of cases, and there is a challenge in the court against this act. So, Home Office's position is, according to the Nationality Act, anyone who was married to the mother of the child at that time will be considered the father. Now, this gentleman is telling us that he was married in the UK at that time. So, I'm assuming that he was not married to the mother of the child at the time child was born. Mm-hmm. But having said that, he hasn't clarified whether the mother of the child was married to someone else at that time or not. If she wasn't married to someone else, then it should be fine. If she was married to someone else, then I think he should keep an eye on this case law. At the moment, Home Office has made an application for permission to appeal against this case. Once a decision is made, Home Office most likely will formulate a new policy out of it.
Okay, moving on to a Tier 1 extension application. Now, someone said for making the Tier 1 settlement application, settlement after extension, it's Tier 1 settlement application, do I need to show my business turnover and accounts again? And he's also asked, after extension, I have employed 2 people who worked for me 22 and 2 months. Does it satisfy the requirement?
Yeah, that's the extension.
Well, he's asking a question about settlement, but he's also asked a question after extension.
Okay. Once extension is granted, that means we have already provided evidence to the Home Office of your investment and genuineness of the business. But once when we make an application for indefinite leave to remain, genuineness test still applies. So you will still have to show that it's a genuine business, a subsisting business is running properly. You don't need to show the evidence of investment that has already been made. That evidence does not need to be shown. So there is a section in the form where you can take that all the money has already been invested and as part of a previous application. So no further evidence needs to be provided for investment. But the fact that business is still running and it's a genuine business, this evidence needs to be provided. Business accounts, it can be shown by business accounts or any other means to show that business is up and running. With regards to employment, you still need to show that 2 settled persons have been employed in the UK after the extension. So at the time of making an application for indefinite leave to remain, you still need to show that 2 persons were employed for at least 12 months each. For indefinite leave to remain. So out of those 24 months for extension, because you get 2 years after your initial 3 years time, you still need to show out of those 2 years you have employed 2 people, 2 settled persons for at least 12 months in the UK. Okay. And with regards to whether it could be part-time or full-time, same rules will apply which will retire at the time of extension, depending on when you were granted your first leave to remain.
Okay, thank you. Now, moving on to the recent Supreme Court case on the best interest of children under the 7-year policy, what would you like to say on that?
Yes, there is a recent case from Supreme Court. It came, I think, 24th of October, so very, very recent, not more than a week ago, less than a week ago. It's called KO Nigeria and others. This case obviously went all the way to Supreme Court, where uh, Supreme Court has finally given a decision and settled dust on this type of issue, where whether the immigration history or character of parents of a child who has lived in the UK for 7 years, means a qualifying child, would parents' immigration history or their character or their bad behavior, bad character affect the best interest assessment of the child whilst assessing the application.
Mm-hmm.
Supreme Court has decided that it should not. It should not affect that assessment under, I think, Section 276 ADE, subsection I think 1 and Roman 5. So when the Home Office is taking an assessment of reasonableness, or whether it is reasonable to remove the child from the UK or not, the fact that parents have bad behavior, they have bad immigration history, should not affect this assessment directly. It however does affect indirectly, of course, but it should not affect directly. Supreme Court, however, did not stop at this point. They went on to give further direction when it comes to the assessment of Section 117B.
Mm-hmm.
Now, Section 117B is in construction similar to Section 276 ADE 1 Roman 5,
Mm-hmm.
but this is not for the Home Office. This assessment under Section 117B is for the courts and the tribunals when they are assessing best interest of the child. So Supreme Court has gone on to say that even for the assessment under Section 117B, bad behavior of the parents, bad character of the parents should not affect that assessment of reasonableness when assessing whether it's reasonable to remove the child from the UK or not. And we're talking about the qualifying child here, by the way. Qualifying child is someone who has lived in the UK for 7 years, is under the age of 18. So it's a very promising decision after a long time under 7 years policy. We have had a lot of refusals where applications were refused because parents had bad characters. If parents had, for example, some of the parents had TOEIC issues, some of the parents, most of them were overstayers anyway, but some of them had limited convictions, for example, driving convictions, etc. And it always affected the application itself. Supreme Court has decided, no, this is not fair with the child. Whilst we're assessing assessing the application, behavior of the parents is not part of that assessment. So it is something that is very promising.
Okay, thank you. Now, moving on.
We
We
have received a lot of live questions. A lot of it is on TOEIC again. Someone's asking, talk about TOEIC, please. There is no specific question. What TOEIC matter is more or less settled now after first we had Hassan and others, then we had case law of Khan. So this matter has settled down. Obviously depends on whether you fall under the previous immigration rules before the Immigration Act 2014 came into effect or after. If your TOEIC issue was Home Office has refused your application because of TOEIC after Immigration Act came into being, then you will have to make sure that human rights claim is made if you have a judicial review pending with no right of appeal. So this is the recent case of Khan, where courts have decided that you have to make a human rights claim, or Secretary of State should invite you to make a human rights claim in these type of matters. If someone has already got a human rights application pending, obviously it doesn't apply to them, but it generally applies to those who were refused under point-based system, and under the new Immigration Act there was no right of appeal anyway on those point-based system applications. So these applicants will have to make a human rights claim, and based on the strength of their claim, Secretary of State will either certify or give them in-country right of appeal. Anyone who was issued Section 10 under the previous rules, they should have had in-country right of appeal when it comes to TOEIC. So the matter is pretty much settled down. You will have to provide evidence that there was an innocent explanation as to why your certificate for TOEIC was cancelled, or why your results are not considered to be valid results. An innocent explanation needs to be provided If this explanation is provided, you should win your case. It's more like procedural rather than legal argument.
Okay, is there any other last inquiries?
Yes. Well, this is a very common question we get with regards to timeline for postal applications. Very difficult to define timelines depending on which type of postal application it is. Generally, human rights applications, 7 years policy, long residence under 10 years, etc. These type of applications can take up to 4 to 6 months, could be longer. Point-based system applications generally take less than that. Sometimes entrepreneur extension applications, indefinite leave applications can take as long as it takes, really. If matter is under investigation or Home Office needs to assess whether you're running a genuine business or not, they may call you for an interview on these type of applications. So very difficult to put a time frame in. One thing I should mention though is that Home Office has now introduced a new system, new application system. They used to have previously these premium application centers where you can go onto the same day service. They have not been. They will now be replaced by the end of this month, and they have introduced this new website which we have written about, and you can get further information from our website from this, or you can go to the Home Office website and get more information. Where now they have 2-day application system where you can actually go to a premium service, book it online for next day decision, or you can book it for a decision within 10 days as well, and obviously price is decided accordingly. So do get benefit from this system, have a look how it works and see, and obviously you can send us your comments and we can talk about. If you have any questions, any inquiries, any queries regarding that, we can discuss it in our next program. You should be reading these, but I will read it anyway. On discretionary leave to remain, it is usually straightforward based on previous grounds and working full time. Says I'm working full time, but I pay my taxes. How can I bring my wife to the UK? I don't see what the problem is. Gentleman is working full time and pays taxes. As long as he's earning £18,600, he can call his spouse over. So problem would have been if he was not paying his taxes. Well, if he's working, he needs to be paying his taxes. So we can't advise on something like that. Other than that, there was an update which we discussed last time. It was with regards to right of appeal for extended family members for EEA residents. We discussed case of Bangor. We know that there are some other cases pending now in the upper tribunal as well. Our own cases which were pending on this point of law. Home Office has invited us to have this matter stayed until they have formulated their policy, or because they have appeal against this case in the Court of Appeal, this case can be stayed. We have personally disagreed with that position because they have simply made an application for permission at the moment. Secretary of State has not been granted permission in this case. So in my opinion, Bangor is a valid case law at this stage and it should be implemented. So there is no reason for us to agree to have these matters stayed against their permission application when permission is not even granted at this stage. Just to remind our viewers, this is a case law where court decided that extended family members, because there are so many facts involved in these type of cases, the only fair venue to decide these facts is a tribunal. So indicating that there has to be a right of appeal on these type of matters, which is not the case under 2016 regulation. We know Sala, which initially was decided against the right of appeal in first year tribunal, was overturned, but that is only applicable to 2006 regulations, not 2016 regulations. So if you have any matters where you made an application, refused, no right of appeal as an extended family member, you can get benefit from of this case and do challenge those decisions.
And there is an article on our website on this that goes into greater detail should you want to consider it. Okay.
Sure.
There is, I've seen another question. Someone's asked, can the Tier 2 ICT be converted to Tier 2 General?
Well, it really depends. These type of matters, obviously, we need some specific information, so we can't say yes or no on these type of matters. There are some rules that are applicable in terms of cooling off period, etc. So we need a bit more information to answer these type of questions.
Another person's asking, leave was initially granted on discretionary ground. The reason for the grant is still ongoing. Will it be a straightforward application process?
Well, generally speaking, if you're granted leave to remain, discretionary leave to remain, clue is in the word is discretionary. But generally speaking, if it's granted on the basis of some specific situation you had at the time, as long as that situation continues and not just the situation, the law under which you were granted that leave to remain continues, then Home Office should consider extending that leave to remain. They don't do that all the time. So if you have any further grounds to add when you make an application for extension, please do so as well.
And we've received another one in relation to derivative residence card. Someone's asking, can a derivative residence card lead to settlement?
No, derivative right of residence cannot lead to settlement, unfortunately. This is something a lot of people do get derivative right for 5 years, and after 5 years they make an application for indefinite leave to remain, and they're refused on the basis that this category does not have any route to permanent residency, unfortunately. In a lot of cases, a lot of them will have recourse within the immigration rules as well, so they can make an application under immigration rule to obtain visa and obviously get on course towards obtaining permanent residency. So do speak to your lawyers and ask them whether you can make an application under immigration rules to obtain visa, which can lead to settlement.
Okay, and we received another inquiry saying, how can EU citizen age 70 can be qualified person, so can exercise treaty rights, income and health?
Sure. I'm assuming if person 70, they're receiving their pension benefits, etc. One of the ways you can exercise your treaty rights is by proving that you're self-sufficient. So if someone is getting their pension or they have other assets or income from different means whilst they're retired, as long as they can show they're self-sufficient, they can be qualified as a qualified person. Another way of doing so is if you have worked in a country for other than your country of nationality for 12 months and then you reach the age of retirement and continue with your pension, then you can apply for permanent residency directly. So if you are exercising your treaty rights as a self-sufficient person, you need to have comprehensive health insurance, of course. After 5 years you are entitled to permanent residency.
Okay, I think that's all the live questions we've received so far that have been dealt with. Are there any questions that you receive on a daily basis that you would say that is so consistent and then you're answering the same question and again that you think you would want to address at this occasion?
Well, we have put a lot of frequently asked questions. We have put a lot of answers or these type of categories where people inquire on daily basis on our website. So if you have any particular question, do go to our website, browse through different articles our experts have written and see if you can find a solution answer to your question. If not, feel free to email us. We have our details coming on to your screen now. If you can email us, you can email me, Anam, or our general inquiry line, or any of our other experts. Sheriad is not here today, you can email him yourself, and they will be happy to answer your questions. Generally speaking, any frequently asked questions during the week, we do bring it on the table and discuss it with you every fortnightly, and any updates we bring you on the table as well. So I think for this week, this was it from my side. And by the way, Anam also specializes in dealing with family law matters, so child custody, divorce, other issues, financial settlement. So if you have any questions regarding that, you can email her directly, or you can obviously come to our live Facebook and ask your questions as well, or email her.
Definitely. I guess shall we call it a wrap then?
I think so, yes.
Yeah?
I think that's enough for the day. We have answered almost all the
Okay.
questions and covered all the areas we wanted to cover anyway.
Yeah, our details will be appearing on the screen as of yet. So should you have any questions that have been unanswered, or you didn't get the opportunity to put your question down in the live Facebook thing, then you can always email us with the inquiries. You can call us, and we'll be more than happy to deal with all your inquiries.
And bear in mind that your first consultation is always free, so do feel free to contact us. Thank you very much.
Thank you. Bye.